Hello, Assalamu alaikum, and welcome to another episode of LIT, which is Legal Technology and Innovation Webinar Series. This is webinar 10, and I'm Barrister 𝐻𝒊𝒏. Those of you who are joining for the first time, I am an advocate of the Supreme Court of Bangladesh, and I have been practicing for almost over 18 years. And I really have a vision of merging law and technology and anything that relates to innovation, technology, and law. So this is episode 10, and it's a very special episode for two reasons. One, we just celebrated the World IP Day on the 26th which was Friday. And World IP Day is basically a day which emphasizes on the importance that we need a balanced IP system to recognize and reward, the inventors, the creators around the world for their work, and so that we can ensure that their rights are protected and the society can benefit from the creativity and the ingenuity. This episode is also very special because with me today will be my special guest is a very special friend of mine, who I know from my law school days. And it's great that we are still in touch. We are very much in touch, and we have kind of, I have seen him talk about intellectual property and trademark ever since I met him. I think that is where he got his LLM and master's on, but we were in the same school. So I want all of you to meet the speaker for this week's webinar, which is Safeguarding Intellectual Property Rights in the Digital Era, and how the emerging AI related challenges are having an impact on AI. So before we move forward, I want to just quickly go on about the key topics that we will cover, which will be about the new frontiers of trademark and copyright law, protecting and enforcing IP in this new digital ecosystem, and how the emerging AI related IP challenges are happening globally. Globally, people are facing these challenges, and how artificial intelligence, intellectual property, and privacy are together, what role they have to play together. This discussion is going to be very interesting, and we will hear from an attorney who practices in the US and works in a law firm and have been working in IP law, trademark, copyright law for over 7 8 years. So with me, I have today Farzad Panchri. Farzad is a lawyer who has been a very big supporter and enthusiast of U.S. trademark and copyright. He is an attorney there, and he has been practicing there. And he also has a strong background of German law. He also did his law degree from German. And intellectual property law, particularly in trademark and copyrights, Farzad holds an LLM degree in U.S. IP law and a German law degree, and that is what I was saying. We did when he was doing his LLM in U.S. IP law. I was doing my LLM in law and economics, and we were both at the George Mason Law School, Antonian Scalia, and we have been friends since then. In school, out school, we didn't have actually. I don't think we have any courses together, but I
Very
think
much.
we had a very we connected, and we had good friends, and we had a lot of good times. You're right, we didn't have any courses together, but I'm glad that we spent so much time. And I was just just before starting this, I was thinking you came to my house once, and we were doing that barbecue, and I had no idea how to use that barbecue grill, and you were like, move aside, women. Let me do this for you. And I was like, okay, thank God, now we will not die. Somebody's going to do the grilling for us. So Farzad, thank you so much for your time, and welcome. Um, Welcome to this lit webinar series, which we're saying it's about safeguarding intellectual property rights and in the digital era and the emerging AI related challenges. And when I thought of doing this webinar, I couldn't think of anyone but you, because like I said, I when I first met you, and that was the first thing. Oh, I'm doing an LLM on IP law, and I thought, I was like, whoa, I haven't met anybody doing that. And so thank you for that. Tell us how your German law degree and how your law degree in the US, and now that you're practicing as an attorney in a law firm, in mostly working on trademark and copyright, and how that has how it has shaped from since we met. Actually, I know you were also saying a lot has changed.
Yeah, thanks for having me, Tas. Good seeing you again, and yeah, it was great times. So yes, my background is so I'm a German educated lawyer. I finished law school and became a lawyer in Germany. I practiced for 2 3 years in Germany in the area of trademarks too, and then I decided to move to the U.S. In the U.S., I did the LLM in intellectual property law, and then right away started working as trademark and copyright attorney. So my main focus is really trademarks and copyrights in the in the intellectual property spectrum. I have, of course, also knowledge in patent law and trade secrets law, but just just theoretical knowledge which I gained within my LLM. So yeah, thanks for having me. I think it's gonna be a great conversation in the area of intellectual property law. They're merging quite a bit with technology, and also AI is causing some issues. So I think that's going to be a very interesting and great conversation. It has been kept coming up like within the last 1.5 years, I think, quite a lot since AI was introduced. So yeah, thanks for having me.
It is going to be interesting, and like I said, this when I thought of doing this episode, especially, and when I was thinking of around, like, it's the World IP Day, and like, in 2000, actually, WIPO, which is basically World Intellectual Property Organization, where that was the first one, basically decided that a convention came into force, and it was that convention happened in 1970, and ever since 2000 they have been celebrating this on April 26th to be the World IP Day,
Yeah.
and that's what the theme is. Which, like I said, it was initiated with the aim to increase general awareness and understanding of IP around the world globally. And this day is particularly dedicated, uh, on IP and how stimulating innovation and creativity can be. And like I said, innovation, technology, law, I see all three merging. And
Yeah.
which is why, like I said, this webinar is legal innovation and technology. In short, I call it LIT. So, which I
WIPO
thought,
has done much more. So they are, just to give you some background knowledge, the World Intellectual Property Office, they are also they're taking a big part in international globalization of intellectual property rights. So in trademarks, for example, you can file a trademark application in one country and then expand it with rather lower time and money, and also management, expand your trademark to other countries. And they are also playing a big role in UDRP complaints. They're one of the forums where you can file the UDRP complaints. So World Intellectual Property Offices, WIPO, is great. So they need to be celebrated.
yeah, we will talk about that. We'll talk about the Madrid Convention,
Yeah.
which is also recognizing, international trademark and copyrights, and they're doing that in 128 countries. If you register with them, you are protected in 128 countries. We'll talk about that, and a little, basically the theme. Like I said, WIPO is actually doing a great job in protecting awareness, and helping innovators protect their rights, and promoting creativity. What they have done is, this year's theme, they have made it connected it with the SGD goals. This year's theme is IP and SGDs, building our common future with innovation and creativity. So they just don't want to protect IP. They're also saying that IPs, intellectual properties, are connected with the SGD goals. Because when we have true creators, and genuine creators and innovators, if we can help them, only then our common future, and we'll have a society which is beneficial for everyone, which everyone will benefit from also. Because if you're completely dependent on machine generated outputs, nobody's going to be we want to create anything. There won't be any new inventions. So they are connecting that. And I also want to say that IP actually plays a great role in healthcare too, uh, because it is such an important area. Healthcare, the innovations that we see in medicines, during the COVID times, the vaccines, safeguarding those green technologies. We are seeing many new innovations in terms of, green technologies, climate change. So you have to protect those and make sure they're not misused or abused. So if we don't have these kind of protections, you know nobody's these researchers, these companies will not be investing their time and money on creating new products for us that can save life, that can save the environment. So I want to take this conversation further and want to ask you, Farzad, that like I said, you have been in the center of intellectual property for a while, like in Germany and also in the US. And so, why didn't you tell us a little bit about your perspective on, like you said at the beginning, that in the year and a half, even though I disagree with the fact that AI came in a year and a half ago. AI has been there for a while. We just didn't know
Oh,
it
yeah.
was AI. Like the Google Maps, Siri, Alexa, they were all a form of AI. It was just that we didn't say it was AI. It was just when ChatGPT came into place, we started talking about AI, AI, AI.
It
But
became more
AI
famous. Yeah.
has been there for a while, and we were being tracked. Where you're going, where you're eating. Smartwatches have been there. Your movements were tracked. So why didn't you tell us that? How do you think it has evolved over, like you said, like the year? Let's stick with the year and a half. And how do you think, even the fact that everything is digitalized, like we discussed, it's a digital economy now. Everything is online, everybody is online, and how that has kind of had an impact on
IP.
protecting the IPs.
Yeah, yeah, definitely. So yes, you're right. AI was probably there before it became pretty famous with ChatGPT specifically. Um, Technology in general has huge implication on IP and vice versa. They're kind of connected a little bit with each other, since the main purpose of intellectual property laws really is to incentivize. In patent law, it's incentivizing innovations, so it's protecting innovations, and it provides a proper return. If an innovator would just innovate things and then would not get their costs back, like what they spent within, for example, medication to invent the COVID drug, why would they do that? So this is really to incentivize the innovator. In the era of trademarks, it's the same thing. Like if you're building up a goodwill in a brand, and you're spending a lot of time, money, marketing to promote the quality of your services, you need to get some benefits back. And that's in trademarks and in copyrights, of course. It's incentivizing really the artistic works, the creation of the artistic works. If you would just create, I don't know, if you would create a beautiful painting and everyone would just copy it, it's lesser incentives for you to, like, financial incentives for you to really create those artistic works or live off that, of creating artistic works. So it has been always connected more or less with technology. It was always intertwined with technology. Within the, of course, the last years, AI, and also the matter like virtual reality, etc. It has become much more present. There was not moving much in the years before. Of course, with the internet, and then also like copying machines and all these things, they had huge influence on intellectual property law, because people were able to copy things and copy files and all that stuff. With the AI, things are getting now again more interesting. Also with virtual reality, NFTs, etc., and like virtual goods, presentation of marks within the virtual reality and all these things, it becomes again more interesting. Or copyrighted work presentation in a virtual reality. And then AI, of course, AI is playing now a huge, gigantic role. I think in AI, we'd have to separate it from which perspective are we really taking a look at AI. So you have a few options. The perspective and usage of AI as attorney, within whichever field you are. I know that it becomes more interesting. Some legal platforms, such as LexisNexis and a few others, they are implementing AI now also to make it easier for you as attorney, um, or utilize AI in general as attorney. Then the perspective of consumers, if you use AI, let's say, to create an artistic work and copyrights, it has gigantic, huge implications, and we'll get into that, and we have to be very careful how to use that. Same as attorney, and of course, in the perspective of IP owners, etc. That's another thing. So really, layperson, attorney, and then the IP holders, and we can hop into each of those topics whenever you feel
Yeah,
ready to
and
start.
basically before, how, like I said, the fact that the rise in the use of internet, actually everything is on the
Yeah,
internet. So I think that played firstly a huge part,
yeah,
because people will just download something, an image or something, from the internet, because everybody was uploading stuff, whatever it is, on social media or on YouTube. So whenever, without even realizing that once you're on the web, it's there. uh,
hmm,
so we were
yeah,
putting up pictures of this and that and whatnot, without even realizing that you're leaving a digital footprint, and
hmm,
that could be used by anybody. And I
yes,
think even Facebook at some point to basically realize that, like, oh my god, I have so much data, what do I do with this? So they just changed their name, and started using those data in as inputs for their next steps and next projects. And that is when all those litigations started happening, that they were not getting consent. We gave only consent to our data as a Facebook user only,
hmm,
not to use my data or my information for something else. Like, I have been telling people that, even you taught me, like, whenever you're looking for a flight, if you look for it 2 3 times, you will see the price is increasing. So
yeah,
I think you taught me, like, clean your cache, your history, and then do the search, because they know you're looking for it, they know you want it, so they will keep on increasing the price. And I'm like, oh my God, like, they keep track of everything. So you search for a product, and the next day, even I was telling you, I was looking for a daycare center, and then I see, for my son, like ads from daycare center near Virginia popping up, and I was like, how did they know I was looking for a daycare center? So
yeah,
we did see that. And like, and what we have also seen is that everything has changed. Also now, you can trademark a smell, you can trademark a color, like Tiffany blue. Like, we all know Tiffany blue, the blue boxes. And every time anybody sees that blue bag or the blue box, they get excited. So we
hmm,
kind of they actually had to patent, like, copyright that color. So we have not seen that before. Smell, because some perfumes have become, like, very popular. So
yeah,
we are protecting those smell sounds. I have These are like all non-traditional trademarks. Before, we used to know a logo,
exactly. Word, logo.
tagline. Now a jingle, like,
Hmm,
something like the NBC jingle before you start, or like in Bangladesh also, we have some few famous ads which has some nice catchy tunes. They are now, you have to, those are like the non-traditional trademarks which are now being protected, because like, no, I don't want you to use this in
Yeah.
my in, you know, and some of the songs, you know, some parts of the songs are being used in for commercial purposes. You know, Taylor Swift songs, or you know, Kanye West songs, they have some great beats, they want to use it, and then they're like, no. So we have seen this before. We didn't see it even like in TikTok when we're using, oh, this music is copyright protected in your region, it's not there in that region. So before it was not there. Now we are seeing, just because all this is because of the fact that there's internet, and anywhere from all over the world people can access it. So if you're not protected in that other jurisdiction or region, you're not you could not use it. So some of the TikToks that I made when I was in the US, now when I try to play it, it says sorry, the sound is not there, the owner has this did not give copyright to this jurisdiction. I was like, oh man, it just okay. So I have seen that. So now I
Yeah.
can see how of like I said, the power of digital space. This digital revolution has kind of changed everything. So as a trademark attorney, what do you think are the current challenges? Like, you know,
Yeah.
you mentioned some, and can you tell us, like, you know, what type of cases are being filed, like, you know, these days in the courts in terms of, and what, and there are also, I think, there are also great opportunities too. Like, you know, now I see there's a rise in trademark registration and copyright registration. Before, people were not so aware of it. Did people were like, oh, it's okay, I don't need to do it. Now people are a bit a bit alert, and they want to go ahead and register and protect them. So why don't you tell us and give some examples of some cases, like you don't
Yeah.
have to name names, so that we can understand what's happening in the US.
Yeah. Absolutely. Let's first take a step back just to explain trademarks, copyrights, patents, maybe trade secrets, just to get like the basic understanding of what we're talking about, and then we can hop into the areas and discuss also innovation, what implications it has. So trademarks in general, they're protecting brands basically. As you mentioned, it has different. There are different trademark types. We have word and logo as general basic topics. The function of a trademark is to indicate the source of the owner, so the source of origin, which means it indicates who's the manufacturer, who's the owner of this product, or who's the manufacturer and like distributor of this product. So who's selling this basically. Um, and that's also separating it also from copyrights and from other things. Um, the traditional trademarks, word, and in the US they call it design marks, which are basically logos. Those ones are traditional ones. Other countries have different regulations regarding non-traditional ones. Here in the U.S., anything which has source indicating factor, so which is indicating the source of the origin, can become a trademark. So smells, if it indicates, if you're smelling something and you're opening tennis balls, and it gives you like that smell of whatever it is, grass or whatever, and you're connecting that with the brand, with the manufacturer who's manufacturing these. That is something, if you smell it and okay, I know this is this brand, that's where it becomes source indicating factor. So these non-traditional ones, you have a slightly heightened burden. You have to actually create this link between manufacturer and this sort of smell. Colors are more difficult because it gives you really broad protection. Telecom, for example, a German company, they have protected magenta, the color. It's a really specific color. This bright pink. Yeah. So it gives you also, of course, huge, gigantic scope of protection. So the courts are more hesitant, also the patent and trademark offices all over the world, to give you like too broad of a protection, but it's possible. So as I mentioned, anything which is has source indicating factors in the US, other countries are slightly different. Smells, sounds, and all that other stuff. Some of the countries are a bit more hesitant and say, maybe not. So it really depends on the countries. So that's trademarks, really anything source indicating. Copyrights is protecting artistic work. So I'm speaking all from the US perspective. So it may or may not be usable in other areas of other countries. It's all territorial, trademark law, copyright, intellectual property law, so it may be different in other countries. Copyrights is protecting artistic works, so anything, anything really artistic, so any text, any music, any lyrics. And the funny part is that also source code is falling within copyrights in the United States, so you can have also software protected, because it's really the expression what you can protect in the US. So it's something like you're writing an article, it's just the source code. So if you're writing it yourself, and it's original, which means it's you have created it. It's new. It's like not in the public domain, so it's not pre-existing. Then you can have that, for example, protected as copyright. So copyrights, artistic works, really, and then you have patents, which is protecting innovations, and trade secrets, same thing. Um, and yeah, the difference between patents and trade secrets is more, trade secrets is a little bit broader. It can protect any sort of any sort of like valuable information which is not public in the industry, and you use certain means to keep that a secret. It can be any sort of formula, source code too, for example. If you're able to hide it, which is difficult with the internet, you can have basically anything of value protected, and keeping it a secret and not making it public in the industry. Once it gets into the industry, it's the trade secret's gone and everyone can use it. So that's the danger of trade secrets. Patents, of course, no one will be able. If you get protection for like 15 years, and anyone who uses it, uh, you can reach out to them because of patent infringement. So that's really the spectrum. What we're like of IP. I'm focusing a bit more on trademarks and
Add,
copyright.
if I want to add a little bit with trade secrets, before we knew it, is basically like the recipe to KFC, how the recipe to Coke. Nobody
Yeah,
knows.
Coca-Cola is
No,
like big.
Coca-Cola is it's a big trade secret. Like nobody knows, even though we have Coke all over the world. And I used to wonder,
Yeah,
they're
it's
manufacturing
crazy.
all over the world. So how can they know the KFC recipe, like Popeye's chicken, all these, like I think it all's we knew trade secrets to be like the um Chick-fil-A sauce or something of those.
The
They
big
were all
issue is reverse
secret.
engineering. So that's what's called, when people are actually able to reverse engineer your product, you're losing it basically. And I think uh, we know all those like amazing companies which are able to keep it a secret, like Coke, which is just mind blowing. But on the other hand, there are also other companies, for example, Listerine, the mouthwash.
Yeah.
Uh, they were not able to keep it a secret, and it came out to the public, and like a lot of others can use now their formula.
Oh,
So
nice.
they're always great examples, and which is amazing if you're able to actually keep it a secret. Like Coca-Cola, a gigantic company selling a product all over the world, but no one is able to reverse engineer it and like create that specific taste. It's crazy. So it's working where you are able actually to keep it a secret, and not so much in other areas. So you have to be careful. What you want. You want protection, for 15 years with patents when you're innovating something, or trade secrets. I mean, it can be forever if you're able to keep it a secret forever. That's the benefit. I mean, it's not limited. Um, but if you're losing it, then you lose it. So connected with some risk. And then especially with internet and AI and all the other things, it just becomes more dangerous. You know, and it has gigantic implications on everything. Specifically, so for trademarks, for example, let's just hop into the different areas, trademarks and copyrights now. So in trademarks, it has huge implications in the area of enforcement, of infringement. So brands are, for example, being knockoffs are being sold online everywhere on different platforms. It has become a game of whack-a-mole. So you're hitting one item and you're taking one item down, it pops up on five other platforms. So infringement has been like it has been complicated by quite a bit with the internet, with social media, with those different platforms. Some platforms are now becoming a bit more aware. They're giving you in the US, you get like a little bit more protection, like from those firms. You have takedown options, and then in the era of copyrights, of course, same thing. Technology, internet in general, and also other areas, it has complicated it like quite a bit. People are able now to, you're creating a picture, you're putting it online, people are just copying it. So with copyrights, it's a little bit different. When your copyrights come into existence automatically. So when you're creating an artistic work, you are becoming the author of the artistic work and the owner of the artistic work automatically. But to be able to enforce it, you file a copyright application. So you were just talking, I was just remembering what you were saying, like, we're taking pictures and we're uploading it. That picture you're taking, you're the owner of the copyrights of that item, at least from US perspective. And you're uploading it, and if other people are taking and copying it or doing something, they're committing copyright infringement because it's your copyrighted work. Although, I mean, if you would want to really enforce it, you'd have to file a copyright application, and then you'd be able to enforce it here in the US. But like, just a simple example, you're creating I don't know, a little blog post, or you're creating writing an article. It's copyright protection, so everything is really like any sort of artistic work is really copyright protected. And with the internet, it just makes it so easy, and you're maybe not even like a layperson would not even think about it and say, well, it's online, like you can right click it and just copy that picture and save it. Yeah, but no, you can't. It's copyright infringement. So it's insane. And that's what I was mentioning at the beginning, that these technology and IP, they're so intertwined with each other, especially with these groundbreaking new technologies, such as back then. I mean, it was the internet, it was those Xerox copying machines, then the video recorders, DRVs, where you could record things for, like, broadcast it to you, and all these different innovations. They're gigantic. Like, on the one hand, I mean, IP is incentivizing these sort of technologies, and it's, we want that. It makes our life so much easier. But on the other hand, you know if it impacts intellectual property rights, infringement, the usage in a bad way, in a negative way, we need those laws to really limit it, and create rules within that field. And I think that's what's happening also in AI. And last year, I think Joe Biden also issued an executive order in that field, in the area of AI. So we see a bit more regulations now. Copyright Office has issued some statements regarding AI. The U.S. Patent and Trademark Office, they have issued some guidelines and rules in the area of AI. And you get also, of course, like, internal law firm regulations within that field. It's new for everyone. So everyone is like, to which extent can we use it? What, why, where, when? where are the dangers? And that's, I think, where it gets really, really interesting to speak about, from those different perspectives. As attorney, can I use it as attorney? Um, and then as IP owners in the era of trademarks, where can I use it? In the era of copyrights, where can I should I use it? And I think that's where we get into really the nitty gritty and the interesting parts of IP.
It's good to know that some law firms are having their own internal policies, where actually California State Bar has their own guidelines, where they're actually allowing attorneys, licensed lawyers, to use AI, which falls within the framework of their
Mhm.
professional code. Like, if you're doing, but they have to make it, they have to share this with their client, that
Yeah,
they will be using AI technology for their work. So there is a guideline, but it depends on law firms and lawyers if they want to use it or not. So California State Bar, like,
yeah,
California has always been one of those progressive ones, always ahead of things. So
yeah,
that's interesting for me to see. And I've also seen there was a debate going on in terms of, I don't want to go off topic because we're going to talk about AI, like how I want to talk about IPR particularly today. But there are impacts of AI on the academic integrity, how
mhm,
is having an impact on the education sector. But that is
yeah,
for another topic. But I
absolutely.
want to ask you, is like how easy, because now that you're saying, like, if that picture example that you gave, so if I take a picture and if I want to get remedy at some point, if it's infringed by somebody,
Hmm.
the only way is if I had registered and copyrighted it, right? So
Yeah,
how easy is the process made by the government? That plays an important role for me. So if
yeah,
I have a lengthy and cumbersome process and with a huge fee, nobody's going to be copywriting stuff,
yeah,
and then or protecting their trademarks. And then also, if getting, because this thing, where how I see is the damages, quantifying the damage. Okay, so I
yeah.
took a picture, somebody else used the picture. Okay, now I'm saying he infringed my copyright. So how much damage are you claiming? What happened to you? Did you lose $1 million, or did you just lose a one night sleep, or did you just were you just embarrassed in front of a couple of friends? So quantifying the damage is also becoming a challenge, which is why I feel like, not just maybe not in the US, but all over the world, these litigations that when they go up to the court level, that this becomes a crucial issue. So what was the damage? And when you're obviously at that point in time, you want to claim a financial amount, but
Yeah.
quantifying it. So how does the US do it right
Yeah.
now, like in terms of, because you kind of always say, like, I lost $1 million, I would have gotten $1 million, but now I'm not going to get it because you've used my picture, or else I would
Well,
have
you
been
have to prove it, right?
misquoted.
Like,
Yeah, I would have been
I mean,
misquoted, and because of
you
you.
can claim a lot, but at the end, you have to prove that you actually lost, you had
Yeah,
those damages. So I think that's the
that's a lot of
difficult
work for
part.
the attorneys, right? For the
Yeah.
attorneys, it's difficult.
Yeah, I mean, I mean, it's for everyone. Like at the end, like the client has to, show those damages which they actually had, and different laws are providing different remedies in that area. So, IP law and trademark law, copyright law, for example. With trademark law, I guess it's a little bit easier. I mean, if you use a trademark, you see, well, competitors coming into the market selling exactly the same thing. You see the impact on your sales. That can be one thing. Of course, the other thing is how much did the other company make? If they're selling the exact knockoff product and you get sales figures, you know exactly what they made, and like how it impacts also your sales. um, in addition to that, there are also additional means to really prohibit these kind of infringements, like for example knockoffs, etc. If you have like willful infringement, uh, um, um, willful infringement, like really something clear infringements like knockoffs, etc. The law incentivizes it. You have like treble damages in certain cases, so you get the triple of the actual damages. Attorney fees in the U.S., the attorney fees are always paid by each party itself. So in certain cases, as I mentioned, like willful infringement, etc., uh, the attorney fees are getting your attorney fees are actually getting paid by the person who committed that willful infringement and all that stuff. And then copyright law, for example, it gives you the option. Um, it's connected with the copyright application. So if you file a copyright application, it has an additional benefits in the area of damages. For example, if you file the copyright application before the infringement happened, you get statutory damages. Statutory damages means, so as I mentioned, it's very difficult to prove. You have an artistic work. And now you have to prove like that it actually hurt you that someone else is using it. It's very difficult to prove that. So statutory damages is like you get basically like X amount, and it makes it easier. So you have that tool in your toolbox if you file the copyright application early hand. Um, and before we get into like the filing, how easy it is or how difficult it is, your second question, um, I wanted to take another step back and just quickly talk about what you mentioned regarding usage of law firms, and then that California bar allowed it, because it's also a very interesting topic. So you have to be careful with that. There are also courts. There are actually lawsuits. Like apparently, some of the associates were using AI to create their complaint or parts of their complaint, which
There
is
are
unfair.
fake cases. There are fake case laws that
Yeah.
refuse.
So
Yeah,
that
yeah,
that
I read
that's
that.
exactly the point. So you have to be careful. Many law firms, etc., are saying uh, you may be able to use it, but you have to use it as first year associate material. So you have to really review it indeed. So it's nothing really reliable. And then what you mentioned yourself, it's called hallucination. So AI is actually making up cases,
Yeah,
which is crazy. So those cases do not exist. I mean, that's generative AI. It's creating, it's you're asking AI to create a text for you. Say, well, create a wedding speech for me or whatever, and it makes up something. It has something here, something there, and it mixes it all together and says, well, here you are. This is the best I can give you. And probably in the area of lawsuits, it's the same. It's like, well, I'll take a little bit from here, from there, and mix something together. It does not know what case law is, that you cannot make up case law. So I think it's still, and apparently AI does not know, like, those people who are creating the source code, etc., they don't know why it happens. So this hallucination, it's called hallucinations, like basically making up things.
and
uh,
a lot of times they're biased too. Like they're also biased depending on the data sets that was put in.
yeah,
Like for example, a friend of mine was using it and said, create an image of a CEO, and by default it was a male. So sometimes these AI tools, when you use it, their informations are also biased,
yeah,
and
of course.
they're all, like you said, they're hallucinations. They make up stuff, so you cannot really 100% rely on them for sure.
Yeah.
But like I said,
At the end, we will use it probably anyway. It's just, it's the beginning. We have to, you have to be careful with how we use it. There are still like some errors here and there, some glitches and hallucination and all that fun stuff. But it gets implemented, and to a certain amount, I think it can be used in the intellectual property field. I think we have to be very careful. So you can't just use AI, for example, for patents, because it's you're transferring the information which the client is giving you to a database, which is like an open database available by everyone. So in the intellectual property field, you have to be very careful. You cannot just use like AI. You're disclosing confidential information as attorney, especially in the area of patents. Very dangerous. And it, like, most of the law firms are saying you cannot, or you should be careful, very careful how you do that. In the area of copyrights, So let's go first with trademarks because it's easy. Trademarks, it's really like, for example, logos, or like give me a good idea for a trademark when I sell this and that. If it's not available, if then you can use that. I mean, it's nothing is really hurting you. Trademarks is a little bit different. Again, you get trademark protection for when you file a trademark application for a logo, for a word, those traditional ones. And if it's available, if no one else had used it before, or no one filed a trademark application, you're fine to do it. If As long as you're selling your product or service under that specific trademark, it's fine. It doesn't matter. No one cares who created that trademark. If it was AI or a person drawing up something, an artist or whatever. So that's fine. Copyrights, and then again, it gets more interesting with copyrights, and that's where like big issues are also happening. Um, also with patents and copyrights. So copyrights is now getting a little bit more difficult. You can't just create, let's say, examples. You have those AIs which are creating pictures, which you were just mentioning, and they're creating like the cartoon version and all that stuff. That's what the Copyright Office was saying. So they issued also some statements in that regard, and there were, I believe, also some case laws. Um, and I believe it's also connected to that one really famous copyright case. It was called the monkey picture
Monkey,
case.
the monkey,
Yeah, yeah, exactly, the monkey picture case. So it's
monkey,
really a monkey is like taking a selfie. Who's the owner
yeah,
of the copyright? I
the
mean,
monkey,
you as the person. You did not take his picture, and again, copyright's coming into existence automatically.
yeah.
And the courts were saying only a natural person can become the owner of the copyright. So the person who has really put that camera there and was expecting to, that a monkey comes and takes that picture. So that is probably the copyright. And same thing with AI. Copyright Office and also case law has now said that an AI cannot be a owner for copyright. It can only be a natural person. So when you create something AI, and the Copyright Office was a little bit more specific. They were stating the input is protectable. So when you're putting something into AI and you're saying, and to which extent you do that, it's really up to you. But if you, for example, having a poem and you say, I have this poem, finish the last two, three sentences of the poem, what you put in, that may be protectable as copyright. The output, what the AI adds to it, etc., it may not be protectable. So it's not really protectable. And with that, we have to be again careful. So the usage of the we're feeding AI with the data, as you mentioned. And when you're putting these things in, it gets just additional data. And what's hindering it to use that exactly that? When you're uploading your picture and you're saying create the cartoon version, you're just giving it some additional information. Maybe it uses that specific picture in its next AI and says whatever, create the next CEO, and it takes your picture, maybe like changes it a little bit and provides that picture. So that's also an additional thing, which usage of those of the data you're providing of your artistic works. You're feeding basically AI with it, and it may use it
It
like
generates something else, and that's like I said, we were in AI, then it's becoming generative AI. Now it's
yeah.
generating something completely new than what you have put in, and that is actually another challenge. So I don't know how this happened. We are almost running out of time, so I want to give
Well,
you we want to go on and talk a few about the few points which I wanted to mention. I wanted to highlight to you, and I'm guessing and to our audience, some fact sheets that I have gathered from the WIPO website. So in 2023, the WIPO fact sheet says that there has been an increase in 718% increase between 226 to 222 in patent applications for artificial intelligence.
yeah.
718 increase, and that the AI market is expected to grow to USD 191 billion by 2024. And
Yeah.
with that, it makes us wonder that what the policymakers are going to do, because there are actually some things that that you were saying that uh, there are critics who want to argue otherwise. Like, can AI be an inventor, or it's the human behind it who's putting that data set, the inventor? So there are a few things that we want the policymakers to consider, is like basically how the AI innovation fits into this current system. That is something they need to consider. And how basically to balance the fact that the value of human and AI innovation, and as AI develops rapidly and becomes more autonomous, because I don't think this is it. We are going to see
Mm.
more and more changes. And we need to be kind of flexible and not come kind of be stuck. We need to have a, like,
Yeah.
broader mindset on what things are coming. We have moved a long
Yeah.
way. And another thing that the policymakers need to consider is, like, they need to make sure that there is an effective IP system, so that when these changes happen, we can foster innovation in an economically significant area. And that is, or else, because the global challenges that's happening all over, uh, basically the questions that everybody's been asking, like, there has been some, uh, like, I will ask you this, like, they're like, so does copyright provide enough protection for AI in terms of models and algorithms? For example, there are AI based inventions that you mentioned, like, which is inventions in which AI is part of the inventive method. But then there are AI generative inventions, where you put in something and then generative AI is creating something different without the human input. So then, can AI invent autonomously? And actually, I wanted to tell you about the Davos applications. Davos is another AI system which is reporting that they're allowed to kind of be have their own inventions without human input. So this allowing are we going to be allowing AI models to be named as inventors? Do AI systems need IP incentives at all? Who
Yeah.
should own an AI generative invention? And is joint inventorship between AI generator and a human inventor the answer? Or, like, would this disincentivize human inventions? So who
Yeah.
is an inventor under patent law? What technical capacity does an AI need to have to qualify as an inventor? And then, would AI invention best be intensified if we use the sus generis, I don't know if I'm saying it right, su generis IP right, which is basically, like, you kind of need to prove that you had a substantial amount of involvement or investment in
Mm.
that, to give you the right, as the inventor. So
Yeah.
everything is so much up in the air. All these discussions are
Yeah.
going on. So as a last take, because, and you also mentioned about counterfeit products. So it's actually the consumers who are, I when I bought a product, I didn't even realize that I was buying
Yeah.
an off or a counterfeit or something. I was just happy I was getting a cheaper price. It should have stuck in my head that you don't get a Tiffany blue box for like $100. But I thought it was the some website said there's a huge 99.9% sale going on a
Well,
Tiffany.
I guess you'll see it after you've used it for a while that it wasn't Tiffany, or
Yeah.
or it was something else.
And there was also these privacy issues that coming up, because, like we mentioned at the beginning, these these human AI tools work better and better with
Yeah.
more data. The more data you put in, the more effectively their output is going to be. So
Yeah.
when you're putting in these inputs, so are you taking are you breaching someone's privacy rights?
Mhm.
So AI, privacy, IP, they're all kind of being interlinked, because you need these data
Yeah.
to inputs in these AI tools, and you need consent. And when they're if you're not getting consent, you're breaching their privacy. And when you're putting these into AI tools, they work better. They generate better results. They will
Of
stop
course.
hallucinating. They will stop hallucinating. They will stop being biased. They will be there. We need ethical outputs and outcomes. So I know we have run out of time, but I want you to kind of tell me your views, or from the United Perspectives of a perspective, how can we approach it, and what are the
Mhm.
changes that we should be aware of, or be ready to come. Because I think right now there's no yes or no.
Yeah.
Nobody can say this should be the law, this is how we should be doing it, because
Yeah.
technology is changing every day. And
Yeah.
I want your views on this, from your German and from your experience, that what should these inventors and creators and musicians and innovators, we don't want them to stop inventing and innovating,
Yeah.
for sure.
No,
And we also don't
I
want to
fully
stop.
agree. Yeah. So I fully agree to what you were saying. Uh, so certain like the usage of AI, I think it's going to happen either you want it or not.
Yeah.
So I think the law needs to be more or less flexible. At the moment, we have certain laws, but it does not mean that you can change your opinion if AI is constantly changing too. So if AI changes, why? I mean, the laws need to adapt to those certain situations. It was the same in the past with the internet, those Xerox, those DRVs, video recorders, etc., etc. Case law is evolving accordingly, so you'd have to really be flexible with those laws. Um, how to use it is really difficult to say at the moment. What I can say as attorney, you have to be very careful how you use it. Really, in certain areas such as intellectual property law, I think it's rather dangerous. So as I would not recommend copyright owner or a certain artist to say, "Let's just go and use AI," because depending on your input, you may not be able to use your output. So be careful. And then with inventions and all that stuff, I would rather not recommend to use it at all, because you're disclosing certain information. If something's already, so trade secrets, for example, is probably a no go, because you're literally giving out the secrets, like publishing something. And same thing with patents. I think it's more dangerous if you get client consent. You may be able, with trademarks, not so much. And then the ownership of AI, there's no really way how you can approach this. Different countries have approached it differently. I think the US approach is a good one. They're saying, so in the era of copyrights, for example, copywriters office is saying, well, only a natural person can become a copyright owner. It's kind of logic. What's the purpose of giving AI ownership of a copyright? Like, the AI is not going to do anything with it. The AI is not going to care about a copyright, and the AI is not going to enforce it. Like, what's the point of giving AI credit for an artistic work? And then it gets now to the question, I mean, who should own it? And then the approach the Copyright Office has taken at the moment, I think is a good one. They're saying, your input, what you're putting in, that's protectable. The output not, because the AI has created something different. The I think the patent office, and I'm not a patent person, so I'm not fully versed in that field. I think they're using that sui generis approach. They're saying, well, if you have created something together with the AI together, the sui generis, like your input, basically your contribution, if it was significant enough, like your significant contribution, that could make you the copyright owner. And then again, the same logical approach, like what's the purpose of giving AI a patent? Probably the same approach as copyrights. There's not going to be a big benefit. And then there was also some talk about the owners of the algorithm, that they should be the intellectual property rights owner. I think that goes a little bit too far. Only because you create an algorithm, you cannot claim all the benefits, because at the end, the input, everything what you're putting into the AI, that is basically used. I mean, yes, you've created the basis for processing that information and providing something, but at the end, it's not really your artistic work; it's the artistic work of others. So copyright is going to be really interesting to see what the future holds. But at the moment, I think that approach is a good one. I think there are other lenient ones, maybe other ones which are saying, well, if like the sui generis one, for example, if you say, well, if you've contributed sufficiently, if you have created, let's say, half of that picture and the AI has just added some filters or something to it, maybe some other countries may say, well, it's okay, you can get copyright for it, because you have contributed like something significantly to it. But the US, I think, has not that approach. They're saying really the input is what you can protect. It's better for a clear, bright line, and then it gets again, it gets really tough to say when you say, well, yeah, you kind of can have protection for it. Where's the line? Like, for what can they have? You can just, add one or two words and the AI is creating the rest of it, or you're just putting a sentence in. To which extent do you get like copyright or intellectual property right protection? And that makes it a little bit difficult. And the Copyright Office has like made up a really clear, bright line. Your input protectable, output no. So you can't go wrong. And like it clears also, it's also clear for the owners, for the inventors, for the artistic work owners, the artists. It's clear for them. They're like, oh, okay, it's clear. Like what I put in is protectable, output not. So it gives you also some security in what you can protect or not. And then again, trademarks, it doesn't play a big role really. So it will probably be used more by marketing, etc., to generate that trademark, to get creative ideas, like to use it creatively. But at the end, the trademark attorney would have to conduct a search, see, are you the person who first used that trademark or filed the trademark application? Is there something similar already beforehand? The clearance of that trademark, whether it's available or not, that's really the attorney. So it
Yeah,
has
and
less impact.
I think there is actually, at this point in time, I think we need to kind of be really updated and vigilant. And we kind of course, US has its own guidelines, which is great because most of these innovations, as we know it, I have seen the data, like China and US. These two countries are the ones filing the most
Yeah.
applications for protecting their IP. So in
Country is really looking at the other one. So it's not so you think everyone is like, well, no, like everyone is doing their own thing, but every country is looking at the other one. How do they
yeah,
approach AI? And it has been always like that in case law. It's funny because if you come from a different country, and like coming from Germany, being familiar with their case law, you see the similarities and you're like, oh, they treat those laws uh like
yeah.
differently. There's some similarities.
Uh,
Same with AI.
so for us, like from Bangladesh, like Bangladesh is moving towards a technological innovation. We are moving towards becoming a smart Bangladesh. We have
Yes.
a vision to be smart Bangladesh by 2041, and we are going to be having all these issues. So for us right now, I think for everybody, I'm going to advise all the audiences here. I think it's very practical to keep a close eye with the WIPO website. I think then because there's this Madrid Convention, I think they are actually talking about a lot of ways to kind of solve these problems, and they're quite updated with the evolving landscape. I think that is one advice from my end with regard to AI challenges and IP challenges and its implementation. And actually, there is no right or wrong answer right now, but we can hope as we move on, as we progress, we will get it one day. Until then, we need to keep these kind of discussions going, these kind of talks going on, and
Absolutely.
share these discussions, talk to your friends, find out like what they're doing, how because there are also cybersecurity measures in this. There are data protection practices that can be implemented here. These businesses and individuals, how can we help these businesses and individuals? Actually, that is the goal
Yeah.
here, to help any um, uh, machines. We are here to help these businesses and these individuals and their IP, their creativity, their innovations. So what more we can do to this? But then again, we do not want to stop using AI because we have seen its benefits. We just need to be a bit careful and be updated, and like you said, be flexible and not be rigid about something, because there are a lot of things, changes are going to be coming. We don't know if we're there yet. But like I said, Farzad, we thought we'll talk. I won't talk for more than an hour. It's been more than an hour. I don't know. I actually had a lot of more things to talk about. We didn't get to it, I think. But it's always nice to have these enlightening discussions. I think we used to do that also, even during the school days. We would be connecting
Absolutely.
IP with antitrust. And I was like, IP and antitrust? What are you talking about? But it's there, and I'm so glad with all the work that you're doing, and thank you for giving us time on a Saturday morning. You should be sleeping, but thank you so
Thanks
much,
for
Farzad.
having me.
A great time. And like I said, a key message to everybody is like, share these webinars and keep on talking about these issues, and be flexible and open-minded, because we really don't know what's coming and what the future is coming. Of course, we need to be a bit careful and not believe everything. Just do your bit of your homework before believing everything that's on the internet, and just be a bit careful before you upload something on the internet, because once you do that, it's going to stay there. It's creating a digital footprint. So thank you, Farzad, and thank you everyone. With that, good night from me.
Thank you.
Bye.